Okay guys, we're live now. Now, we've finished judicial review. I did say it was going to take quite a long time, and it did. It took well over half, almost 2/3 of your subject. So while it's really, really, really important to note that judicial review is a big part of this subject, and it should be. It's a massive part of administrative law. There are some other bits that you guys will need to know about. There are some things involved with the system we have to do with things that don't involve the three great writs of administrative review. And another thing that you may or may not have sort of picked up on, and particularly in the last few weeks, is this idea of the limits to judicial review. And one of the really, really important limits, very, very important, comes back to this idea of separation of powers. The idea that we, as a people, demand through our system of government and our constitution that power is diffused. We don't want to have the same bodies, the same people, having or holding all of the power in our society. It's the fundamental component of the separation of powers doctrine. And now that we've known and looked at judicial review and really tried to see where its place is, which is fundamentally about using the courts to correct legal defects with administrative or government decision making. So it's limiting the power of the executive to do whatever they like. Well, you're using the courts to do that, and you're using the courts through the system, both of some ye-old common law rules and constitutional limits in Section 75 of the Australian Constitution, and most importantly, the legislative framework. So judicial review was about a lot of it was looking at legislative frameworks and saying, hey, this decision maker has gone outside their power. That's really this core part of it. We as the citizen can go to the courts to make them do things, to stop decisions that are unlawful, to say to the world, the executive has gone outside the scope of that. But one thing you might have noticed, again, particularly towards the end, is this genuine fear, this worry that if you could go to the courts and seek these writs and make executive decision makers do what you want them to do, that's problematic as well. Because all you're doing is, rather than cleanly separating power between the three arms of government, you're just giving more power to the courts to go through and do things. And again, when we think about this idea of judicial review, particularly under the statute, it's really about following the will of Parliament. Parliament are the ones that are elected by the people. The other two arms of government, in theory, are subordinate to that. The doctrine of parliamentary supremacy. And if we give the courts the power to make decisions, that's a real problem. And so when we're looking at particularly the broad aspects of judicial review, the courts are very reluctant to step into the shoes of the decision maker and make or remake the decisions themselves. They don't want to do that because it's not their job. The executive arm of government makes discretionary decisions. That is what they do. And there is, however, a mechanism where decision makers make bad decisions. They just take a whole variety of evidence. They're following all of the rules. They're not outside the scope of their powers. They're following the rules of natural justice and procedural fairness. They're not acting in bad faith. They've followed all of the rules given to them under a statute. They've weighed these things up and they've come to a bad decision. And merits review is the system of looking at the quality of the actual decision itself. We are looking at how things have been weighed up and looking at defects and problems with doing that, and systems that you as a citizen can engage with in order to get a better result. fundamentally, we're doing a law degree. We're learning how to be lawyers, and we are learning how to do the best for our clients. And so this system, merits review, isn't really so much to do with the underlying lawfulness of decisions. It's to do with the quality. And as far as our clients are concerned, it's to do with decisions that usually have adversely affected our clients. Decision makers made a decision, we don't like it. It's lawful, followed all of the rules, allowed you procedural fairness, that jumped through all of the hoops, and worked within the framework given to them by Parliament. But the decision they came back with, we didn't like. We think they did it wrong. And so we're going to look at how merits review sits into this system, to step into the shoes of the decision maker and remake decisions. Okay, bit of history. Go back, I don't know, 100, 200 years. You still had tort, you still had contract, and we kind of had what we would call administrative law. But I've made this point a few times throughout this subject, that the idea of seeking writs usually wasn't people trying to get writs in order to stop administrative, what we would call administrative decision makings. They were usually used against judicial officers, essentially like an appeal system before there was the statutory framework and system of appeals. And that was fine when everything was hands-off, laissez-faire. People did their own thing, and only if there was a problem did you need to go through the court system. If only there was a dispute between two parties in a contract, for example, or if some person got directly willfully interfered with, you'd need to seek a remedy in tort. And that's because there wasn't the money and the systems in place to regulate society. If we think about the how things operate, and it's kind of still true in places. I don't know how much traveling people in this room have done over the years. But when you go into developing nations, you'll still see these sorts of places where people do their own thing. It doesn't have this level of regulation. Australia is a heavily regulated society. When you walk down the street, when you cross the road, you see this in action. You see speed limits in place. You see road markings on the road. You see that everything is clean, generally clean. People do come along and clean things up. The gardens are all maintained. And there's no signage. People can't just put advertisements all through. And here I'm thinking, I walk along Riverside Boulevard every morning. It has that in place, and we don't have to think about it. It just works. How does it get paid for? Taxes. We have come to this point in human development where we like that. We don't want to have to think about it. Our society is heavily regulated because we think that's the best way of living. But this didn't just pop into existence. These things took time. And really, it's after the war, after the Second World War, that these systems of regulation really started in earnest. The baby boomer generation had really received sort of the benefits, I suppose, of the post-war prosperity. And part of that prosperity, coupled with the fact that the federal government took the income tax. You may, again, this is an issue in constitutional law for those that haven't done it. You'll learn about the income tax acts in Australia. To fund the war, the federal government took income tax from the states, and then in the 40s, 50s and 60s, just didn't give it back. So they kept it. So the vertical fiscal imbalance with state governments being broke everywhere, going to the federal government with a begging bowl has persisted. But armed with a bit more cash and a public eager to have aspects of life it made them more structure as a result. Family law, consumer law, and the important thing for us in the 70s was administrative law as well. And now, you look at the dates on these things. They had this thing called the Kerr review. Apologise for my accent. In the 70s, and they looked at the systems that were in place, because there were a lot of systems where you could go and seek review of decisions, but they were all over the show. Queensland had this as well, same system, where you had many systems of review that had grown organically. The Veterans Review Boards, for example, systems where decisions needed to be made because there was a statutory framework in place. And these things happened a lot after the war, and the reason for that, because there were more veterans that needed to go through and to do these things. Australia also entered into a variety of treaties after the war as well that needed to be enshrined in domestic legislation. A lot more regulation came into being, and people were more accepting of that. We accepted that residential tenancy, you can't use the basic laws of contract. Consumer law, can't use the basic rules that two arm's length abstract individuals have. Needed to make these things regulated. And to create some sort of order from this chaos, Parliament enacted the ADGR and the AAT Act. The AAT is the Administrative Appeals Tribunal, and that name can be a little bit of a misnomer, because they can hear things at what we would consider to be first instance, and hear things de novo, afresh. Now, there's a variety of other statutes that are out there as well, and again, we're going to be talking about these other areas of administrative law over the next 3 or 4 weeks up to the end of the semester. This idea of freedom of information, which now we look at it as quite a critical component of administrative review, and that's being able to actually go and get the information that decision makers are using to actually make the decisions that they give to you. Freedom of information forms its own check on the arbitrariness of government. It's a bit difficult to arbitrarily make decisions on a whim when you've got to write it all down as part of that process. There is a Federal Privacy Act to do with your information, your rights to access that information, and protections, particularly in regards to government agencies and third parties with your information. The Ombudsman. We'll spend a whole week talking about the Ombudsman. The Ombudsman is an independent body of investigation and review that reports directly to Parliament. It's not, strictly speaking, a government department. It's independent of government and reports directly to Parliament itself. And its powers are limited to investigation only. It can't do anything directly. It can't change decisions that are made. It can only cast light upon them, bring them out to the open. Now, in Queensland, there were a vast variety of tribunals with all sorts of different names that were created under a variety of different statutes. And about 10, 12, 13, 14 years ago, they had a review and said, look, this is crazy. We've got all of these bodies that do similar functions of review of decisions. We should really unify them and have one set of regulatory framework. It's one piece of legislation that govern those in terms of the systems, in terms of how they're structured, how they're funded, even if particular matters require expertise from different members. Some members are required for some types of matters, for example, residential tenancy. Other members are required for other functions. And again, here I'm thinking the various administrative review systems. QCAT in Queensland is also responsible for minor civil disputes, dividing fence disputes, consumer traders' minor debt disputes. It's basically a catch-all to essentially create a low-cost environment where you can have things resolved. QCAT's dollar limit is $25,000. The small matters, you can go there. It's much cheaper, and you don't have to have legal training to do it. But for the purposes of us, we're interested in their review function that's given to them by statutes, various statutes, in order to review administrative decisions. Okay, and this is from Chief Justice, I think he's speaking ex-currally, yeah, so it's just the speech he had about 10 to 12 years ago, talking about the AAT, and it, and one of the sort of the key points that he noted here is that when you have people whose job it is to review decisions, they're much better at, not strictly speaking, the making of decisions, but at least checking them over. I like to use the phrase a sanity check. Do you guys know what I mean by a sanity check? It's where you look at numbers, or you look at data, or you look at something that's presented and you give it to a third party, and they look at it to determine what you're doing is crazy or not. Does this make sense? This is a commonsensical look at it. And people that are very good at the system of review, sometimes they don't strictly speaking need to have this very deep expertise in the actual subject matter itself. It's the process of weighing factors up reasonably to come to a particular result. That is its own set of skills. And so the people that do and sit in the AAT have that experience and that expertise. It's part of that process. So I quite like that. It's quite a nice quote. Okay, what is merits review? It is, it's the system of a tribunal remaking an administrative decision. It is that simple. A particular decision maker has made a decision, and here, in theory, courts could send common law jurisdiction, but to a tribunal. I'm not quite sure how that would work. In theory, I suppose it could. But I'm not concerned about that. What we are concerned about here is enactments. And so that from this point forward in the course, on the subject in administrative law, I'll specifically mention in situations where I'm also referring to constitutional or common law writs. Right, they will be the exception, and I'll mention that and explain it. From this point forward, assume everything's done under statutory frameworks. Okay, so when we're thinking about merits review, we're thinking about the statutory functions that are conferred by legislation to send a decision to the tribunal for review. Okay, and again, this can be done in a variety of ways that I'll talk about in a minute. But just make note that because these things are done under a statutory framework, really important thing to know if you guys are going out to the world, which you are going to be doing very soon, is that every statute that refers to the AAT or to QCAT will explain how that's done. And often there are other systems and steps that have to be done first. Okay, there are steps and systems that have to be done first, usually in terms of what they call internal review. So if you don't like a decision, I'm going to use the CSA, the Child Services, Child Support, I think it's Child Services Agency as an example, because I've dealt with them most recently. When you have a decision, in this case, the calculation for child support repayments and mechanisms for doing that, there is a system of internal review that must be done before you can go to the AAT. The veterans boards would certainly have that structure. A decision will be made, and they will say, if you don't like this decision, you usually have 28 days. In most statutory frameworks, 28 days is the de facto length of time in order to seek review. I have actually seen situations where the decision makers have given a shorter length of time, and if ever I've queried that, I've never had it not extended when I've asked for more time. So again, these are, from this point forward, you guys are going to be picking up some practical skills. I like these parts or these areas of law which you can walk out of here learning some things and be ever so slightly more powerful when you deal with these bodies, knowing how these systems work. They're little bits of information, but they can be very helpful. Contract law, for example, learning the rules that we did yesterday. Very, very helpful things you can learn now. Other areas of law, judicial review, it's going to be a little while before you're going to put them into action. The merits review and the bits you can learn about tribunals, you can tuck these away and they can pop up, and they may pop up very soon. In fact, for some of you, there may well be things you could apply these to right now. And so you do need to note that every statute's different. It refers matters to the AAT or to QCAT, and they will invariably have a system, a series of steps of things you have to do before you can go and have your decision reviewed externally. Because the key thing about the AAT and QCAT is that while they're independent of the statutory framework that you're dealing under, so for example, the Child Services Agency, the Veterans, I'm not sure what the statutory framework is for that, but certainly Centrelink, while these things are separate and are run and managed distinctly and separately, they are still arms of the executive. Tribunals are not courts. They do not have the same structure. They do not have the same constitutional backing as courts do. They look like courts and smell like courts and look like they have very similar powers to courts. They are not courts. Tribunals are essentially an arm of the executive. And if we actually take this a step further, it's really the executive, and also Parliament as well, mapping these things out in advance, essentially being nice. Hey, we're the executive. If Parliament said that we would have power to do these things and they couldn't have this review system, it wouldn't exist. But we, as citizens, have demanded it. Thus, this ability to take decisions that have been made under an enactment of an administrative character can be taken to these ostensibly independent bodies for review, but it's fundamentally not the same as going to the court system and having the courts make an order about the legality of a decision. Tribunals are not courts. Okay. Now, these systems under a statute, most of the statutes, that the steps you must go through before you can go and have your decision reviewed usually involve asking the administrative decision maker to remake a decision. You can do that in common law anyway. You can go through and ask a decision maker to remake a decision. So if you have a decision you don't like or you're not happy with, usually as part of the statement of reasons or the letter or the notice that's given to you, we'll have the systems that you can go through and do. And usually at that point, by the way, you're going to have some streams, because at any given time, administrative decision makers have to follow the statutory framework given to them. If they don't do that, that's judicial review. You're going to get this option to go to the courts whenever they're outside the scope of their lawful authority. It's strict or narrow ultra vires. But if we're concerned about the quality of the decision itself, that's where we can go through and have a decision reviewed. Okay, I know I seem to be sort of labouring on that point, but really that's the point of this whole area here. Getting your decision, the quality and all of the little factors weighed up by a decision maker, getting that redone. Okay. Now, when I say tribunals are not courts, they look a little like a court, and in fairness, this is more a tip rather than a strict rule. When you go into a when you go into a tribunal, often which are in the courtrooms, certainly in the Townsville Magistrates District Supreme Courts, QCAT will sit in the Magistrates Courts, or they will sit in the smaller courts on the other side, the District and Supreme building. Treat it like you would treat a court. This is a piece of advice that the people who are sitting on these boards are usually very senior. They're not sitting as judicial officers, but do the exact same things you would do as if you were going to court. That is a piece of advice that I give you. Show the same level of respect. Refer to the members as Your Honour, even though you're not strictly speaking obliged to. That's just a piece of advice for you guys conducting yourselves from this point forward, because you may have to go to these tribunals, between now and when you actually hold a practicing certificate. Okay, but there are some key things to note, that as well as the fact that constitutionally they're not courts, there are procedural things that make dealing with a tribunal, for most people, easier. For us, it's a little frustrating, because at some stage, you will know the rules of evidence. Tribunals, by default, do not follow the rules of evidence. And that's an important thing, because the rules of evidence are complex. The rules of evidence have been developed over 1,000 years. The rules of evidence are there to actually provide fairness in the process. They're not designed to hinder or thwart the role of the court of finding particular results one or the other. The rules of evidence are actually there to make things fairer, but we accept that they are very opaque, and it is not fair for non-lawyers to have to follow the rules of evidence when going and having either decisions remade or low value disputes heard in a tribunal environment. And so I apologize here, because I'm sort of mixing and matching between the QCAT's appeals and administrative review function, as well as their other functions, which is to hear residential tenancy, minor consumer, minor debt, dividing fence disputes, which makes up the vast bulk of their time. Now, can tribunals follow the rules of evidence? Yes, they can. They can choose to, but they're not obliged to. The way that the tribunals are set up, it is to encourage a low-cost resolution of a dispute, and the administrative function, and having decisions reviewed, a low-cost mechanism for having a decision remade. That low-cost aspect is not to be understated. Has anybody here sat in on a full jury trial of an indictable offence in the Supreme Court? You look around the room and you look at how much everyone's being paid, and you look at the fact that there are 12 people over there that have to listen to that whole trial, not working, just listening to this trial, and then you get to the end of it and somebody blabbed something to the jury and the whole thing is called off. You think, well, that cost the Queensland taxpayer. It is very expensive. And the QCAT and the AAT are designed to ameliorate that. Look, we do want decisions to be able to be reviewed, and we've set up a body to do that, people who are good at reviewing decisions, but fundamentally we don't want lawyers to be involved. When lawyers get involved, things start getting expensive. That's because of what you guys are doing now. You have to come here through law school, spend 3 or 4 years doing and studying all of this stuff, then go through the PLTs, then go through the admission process, then pay your fee, then get your practice over, then do your CPD. All of that needs to be costed out somewhere. It doesn't come for free. Most people, very few people, go through all of law school just to get a volunteer's practicing certificate. That's quite a rare thing. And so all of these things need to be accounted for and paid for. And the tribunal system, look, we want to bypass that as much as possible. But note, the flip side of that is that while the rules of evidence are not strictly right, you're still supposed to really adduce evidence which is actually probative, that tends to prove particular matters. And a lot of the rules of evidence, particularly the two rules of admissibility, that everything must be firstly must be relevant in order to prove something, and then it must be admissible, following all of the various steps, can't be hearsay and so on. If the tribunal has the choice between following these rules, even loosely, and not, they ought to tend towards doing that, because we've developed these rules for things to be fair. Okay, so just make note, that cost aspect is really important. Merits review is supposed to be cheaper, tribunals are supposed to be cheaper than courts. All right. Hearing de novo. That's a term to mean when a decision goes to the AAT or to QCAT, it is reheard. It's an important concept in merits review because the administrative decision maker, when I say they're removed from this process, the information that they've taken and how they've weighed it up and the statement of reasons that they had, all of those can be relevantly placed before the tribunal. But the tribunal steps into the shoes of the original decision maker, right, and rehears it to make the correct and preferable decision. That's the purpose of that's their job. That's the purpose of their role. The administrative decision maker is removed from the process. It goes to the tribunal. They step into the shoes, is a really good phrase, of the original decision maker and rehear things. All the evidence is adduced, it's given to them, and usually this is in the form of a full rehearing. Again, in some situations it's not. Parties don't have to do that, they can just send the evidence across. But usually you're given the opportunity to have a full rehearing, and because we're not strictly bound by the rules of evidence, you can adduce new evidence if need be. The whole purpose of this is to try and solve the problem. And so if new evidence solves the problem, the decision making, then that in itself can be fine. All right. Okay, policy. I talk about policy a lot, largely because I think administrative decision makers who are very well paid don't understand how policy works, and it frustrates me to no end. When we're talking about judicial review, acting at the behest of others, or blindly following policy, policy is just a series of predetermined decisions and essentially a list of bullet points to guide administrative decision making. It is an error of law in judicial review to follow it blindly. But decision makers can follow it. They can follow it. Hey, the whole reason that the government of the day, the minister, has put in these particular policies is for political reasons. Hey, we think, based on the pulse of the nation, or the state of Queensland, this is the best way this government department should operate. And so if decisions come up, particularly when there are many decisions and they're very, very, very similar, here is a list of things that we'll go through and do. Yes, you can't apply it blindly, but most of the time it's going to work. So start with that. And that policy has been dictated. It's been dictated from essentially the political process. And the merits review, when they're going and examining that, they can take that into account. They can go through and look at what the relevant government policy was and how things can go through and be weighted, and what things the decision maker can and ought to do in order to reach a particular decision at the end. The correct and preferable decision can and ought to incorporate that as part of it. What does the minister want? It's actually a relevant thought. It is relevant. It is something that the AAT and or QCAT can examine as part of this process. Clearly they can't do exactly what the minister wants, and that's because following the policy blindly is often, obviously that it's going to lead into difficulties of judicial review, but in situations where the policy is there and it's ended up in the merits review in the tribunal system, certainly the tribunal can look at that policy and examine it and look at it on its own merits. There are some rules in terms of tribunals, how they go about interpreting things. Now, one of the difficulties with tribunals, they're not courts, and as such, while they have a statutory framework that they operate under, things can get complex when there are rules, legal rules, and those rules have changed. Rules can change from time to time. And if we think about it, if law was fixed at a certain point in time and something goes to judicial review, all right, the law here, point A, and the law in point B are going to be the same. The courts are going to go through and look at that. And that's not going to be problematic. And the courts, because they're determining at a particular point in time what the relevant rights of the parties was back in time, it's retrospective in nature. If the law's changed, the courts can go through and reanalyze that and take that into account. It's a little bit trickier with tribunals because of their very nature is to not go through and look at the underlying lawfulness of particular things. So they're kind of stuck in some situation in that they are making a decision that's made at a particular point in time and remaking it. Because they're remaking it from scratch, they have to go through and update all of their the decision-making process based on what particular rules and policies that have changed since then. That can be a problem, particularly if government departments change their policies when going through the process. So if you're going through and I've booked to go to the AAT and a relevant government department changes its policy, sometimes that can render the entire decision that's going to go to the AAT or to QCAT. If they followed the policy, it's going to lead one way or the other, radically alter the positions. The tribunals they still have to go through and follow that and take that into account. The minister can go through, change policies, and the decision needs to go or be updated with whatever's done at a particular point in time. The tribunal's obliged to go through and do that. Okay, now I mentioned about the rules of evidence. They are not obliged to follow them. The rules of evidence don't strictly apply to tribunals, and you, by default in QCAT, and I believe in the AAT as well, I haven't actually gone through and checked this, so by default you can't take lawyers in with you. but you can if both parties agree. So both sides agree that they want to take legal representation, they can do. They're designed to be low cost, they're designed to be simple, they're designed to reach resolution of a particular matter. And in the administrative law sphere, it's to quickly, cheaply, effectively remake an administrative decision and replace it with the correct and preferable decision. But notwithstanding the fact they're not strictly bound by those quite complex rules, the information that is presented still must tend towards proving things. There must be some logical connection to it, even if we're not going to use the very strict interpretations of the various courts in regards to the rules of things like relevance, and rules of things like hearsay, and rules of things like unlawfully obtained evidence. All of these things still must have some internal logic. Tribunals are bound to follow a logical, reasonable, and rational series of steps when they're examining all the evidence that's adduced to reach a particular result. And as I'll talk about a little bit later. The tribunals, interesting, are inquisitorial, essentially, rather than adversarial. They can ask questions, and they do. It's very annoying when they do, but they can do. I love this line. Quasi-judicial. Courts are not tribunals, but they look like them, they smell like them, they have the powers very similar to them, they're making decisions that determine people's rights. Two sides usually rock up. And so they use this phrase, quasi-judicial functions. And again, was that Justice Brennan? Yeah, that's Justice Brennan, that's Pucci. Pucci, which is your question for this week. It means, I love this, they must, or that he, gendered language, even in the late 70s, the decision maker must not spin a coin or consult an astrologer, but they must take into account any material as a matter of reason, has some probative value, that is, tends to prove a particular matter or fact. You've got to go through, use evidence that tends towards proving things that are irrelevant do not satisfy that. And some of the big ones that can come up are character related and things that relate to similar matters. The person's conduct in a variety of previous matters and or a person's character. Those are things that don't tend towards proving particular facts in a tribunal. Yet, if you don't apply the rules of evidence, strictly speaking, the tribunal could take them into account, even though they don't tend towards proving things. And the courts have consistently said that no, tribunals need to actually be logical in their thought process. Okay, what we're going to do, I think we'll pause it there and take a few minutes, and then we'll come back with a little bit more afterwards, look at standing and some other things. By now, you guys know a little bit about standing, because in some places it's complex, in other places it's not. The rules for applying to the tribunal in terms of standard for the AAT for administrative decisions is really wide. It's not a person aggrieved, it's a person whose interests are affected. An organisation or association of persons, whether incorporated or not. So it's a statutory right for unincorporated societies to bring an action in the name of that body. It's just, yeah, it really just is that. Those are the two key pieces of information. It's wider than a person aggrieved. You only have to have your interest being affected. That's interests, not special interests. You don't have to have anything particular to you, just some connection. It's not a very high bar in terms of standing to bring about administrative review of a decision. I actually don't have too much to say about that. It's just a much broader test. You can do, so for example, if you are a person who, for example, you've lost your license, or what have you. If I've lost my driver's license, I can't go to work. If I want to seek review of that decision to cancel my license, that's perhaps not an example, because that's usually there's a strong stat framework for that. Maybe a fishing license. If a person, as an employee, has lost their license to fish in a certain place, a personal quota or whatever, I'm not sure how these things work, and you as the employer could seek review of that decision because your interests are impacted in some way because it was one of your employees. But that also extends to things like family members. If it's a very, very low bar in terms of doing this. And the idea is that at the end of the day, doing things through the tribunal system, because it's so much cheaper, the courts have always had a reasonably high bar in terms of standing to stop all and sundry, mere cranks and busybodies, to quote Lord Denning's words, from stepping in to be able to use the court system. The court system is expensive, time-consuming, and clogs up the system of government. The tribunal's much less so, because decisions that you made in going through the tribunal system can actually be done much, much faster. And if we stop and sort of think about that, not needing to go and look at very, very carefully delve into the underlying legal mechanics of a matter, just getting the evidence and rehearing it, that process is logically a lot faster to do. Don't get me wrong, as you and I'm sure can probably attest to this, when you apply to the AAT and when you actually get your hearing, there's usually a delay, a non-trivial delay between those things. But in my experience, relative to the court system, it's much, much smaller. I said the last time I went to the AAT, it was only a few months after applying. Okay, so that's just thing to know. Look, just tuck that one back in your mind. Standing is just a lot easier under merits review than judicial review. Appeals. Now, one of the things about the AAT here, I'm thinking more here, but also QCAT too, is that it's strictly speaking not adversarial. We think of the adversarial system, two sides adduce evidence. I bring my evidence, you produce your evidence. And the judge sits on her or his chair, doesn't go and do any investigations. That's not how tribunals work. And tribunals, again, particularly in this administrative decision-making role or mode, they're trying to find the best or correct decision. And as part of that, they can ask questions. They can go and do things. They actually have scope, discretion of their own to go through and not just ask questions of the people producing evidence to the tribunal itself. They can also refer matters. They can refer issues of law. Because from time to time, when the AAT is hearing things, a particular decision that's again purported to be made under enactment, the AAT may not be clear about what the enactment is or how it works. And so those issues of law need to actually be referred, and they need to be referred to a court. Okay, I've put the QCAT, and the QCAT, what do we call the QCAT Appeals Division. QCAT, its appeals system is sort of twofold. QCAT themselves will have a hearing at first instance, all right, which is usually done in front of either a member, who's usually a sitting magistrate, doesn't have to be. It can be appointed members, but usually for disputes that involve things like consumer disputes, they will have a member who is a justice of the peace and a solicitor, and another member who is not usually a solicitor and is a justice of the peace. They constitute the QCAT for those particular hearings. Now, when your matter is heard, you're going to be throwing a variety of bits of evidence towards the members, and the other side will be throwing bits of evidence towards the members. And you're also going to be talking about law. Part of this process is that these are decisions that are made under an enactment, and so how those enactments are interpreted, those are questions of law. And so the way that works with QCAT is that decisions of law, if you don't like a particular decision that's made, you can seek an appeals. QCAT has an built-in appeals division. It's the QCAT Appeals Division. The citation will be QCATA. You can, by right, appeal a decision on issues of law. You can, by right, do that. You got to pay $400, which is really annoying because it's non-refundable. So if your matter is not $400, yes, you can appeal it, but there's no guarantee that even if you're right on your issue of law, that you're going to get your fee refunded for the appeal. You can also appeal to the QCAT's Appeal Division if it is a mixture of fact and law, or it's just the facts. You want the Appeals Division to just look at the facts. But there is one important distinction between those latter two and the first one. It's just a matter of law. You can appeal by right. This is important for you guys, because you're going to find, if you're going into a court, to a tribunal from this point, if you think about it, unless you happen to be up against somebody who's also a solicitor, you're probably going to know more about the law than the person you're up against. It's one of those tactical advantages that you will have from this point moving forward. You're going to know more about the law, doing things like statutory interpretation, than most lay people. You just are. You've gone to law school. And the fact that you're not fully qualified solicitors doesn't change the fact you are going to know how to do these things better than people. Nope. None whatsoever. Member can ask you what you do. It's an inquisitorial mode. Why are you not telling us what you do? But you get that benefit. You can't be excluded from QCAT. Remember how I said that you can't take lawyers into QCAT or the AT unless you have permission from the other side? Does not apply if you are a lawyer. Don't get me wrong, the QCAT members know this, and they know that that aspect of it exists. But as a result, when you are hearing or going through and having a matter heard, be very, very clear about the issues of evidence, the facts, and the issues of law. Because if you're appealing on issues of law only to the QCAT Appeals Division, you can do that by right. The only thing you have to do is pay the $380, and you can appeal. assuming you didn't win in the first instance. If, however, it is an issue of fact or a mixture of law and fact, you must do a thing called seeking leave. And the QCAT Appeals Division will only grant leave if you can prove there's some form of injustice has occurred, there's some defect. And that is something they don't do readily. You have to demonstrate as part of that. As part of your application process, you're going to have to demonstrate that to the Appeals Division in order to be granted leave to actually be able to have your appeal heard. Again, usually as a heard de novo. They'll look at the evidence and then determine essentially whether the original member did the thing incorrectly. The QCAT Appeals Division are judicially trained members. I think they're all magistrates, but I can't confirm that. So it is actually an important, and it seems like a really minor point, but when you're going from this point forward, and you're going to be going out to practice, to legal practice, and from day one, you're not going to probably get given this piece of information ever again. Maybe Kita will. She's pretty good like that. But from a practical consideration, for you guys going through the tribunal system, that if the member, and look, most members you're going to be dealing with, if they're non-judicial members, they're not magistrates, they're not going to know everything about the particular area of law, particularly if what you've got is quite complex. You need to set things up so that if you do lose, that it's just on issues of law that you want to go and appeal through. That's just a tactical thing. Like I said, I'd tuck that one away in the back of your head, pop it out at some stage later. So just make note that where there are issues or legal defects with the AAT, while it says there the AAT can refer questions of law to the federal court, if there are areas of law as well, you still do get the right to go through the court system to have issues of law corrected, legal defects. And if you do have to go to the federal court, or again, this can happen if the QCAT the Appeals Division, you don't like what they've said about the law, you can go to the Queensland Supreme Court, or Court of Appeal, I should say, Queensland Supreme Court of Appeal. In the federal system, in the AT, you go to the federal court. Look, they don't usually rehear the facts, particularly in QCAT, because you've already done that twice. But they do have power under the referring statutes, the appeal statutes, to do that and actually rehear a matter from scratch. But they're loath to do that. Okay. You notice that these things with merits review, look, it's a little bit hodgepodge. There are particular rules that you need to know, because the principle of merits review is actually pretty simple. It says a tribunal, they step into the shoes of the decision maker, they remake the decision by weighing things up. But that conceptually is quite similar. There's just a variety of little rules that you'll need to know. One is about self-interested litigants. It is in the interest of justice that people represent themselves. It's one of the core functions of the tribunal system, is that we don't want lawyers to go in there. Lawyers are expensive. Lawyers create some sort of perverse incentives for people for doing things. They clog up the system. And so the starting point is that you have self-represented litigants. That can be problematic for people with low cognitive abilities. And so there are systems in place for people to have support, non-lawyer support people, translators. For those that have gone to the Queensland courts here, the Court Network, which is a volunteer organisation, which goes essentially to just act as a welfare person. They will have people that will just come and sit next to you, or sit in the court to you and just listen to you talk, so that you've got somebody there to sort of be supporting you. Those systems are in place. But yeah, make note that you can actually go and ask the tribunal to have legal representation, somebody actually stepping into this environment, and they do everything for you. And this is It's actually interesting because when I say it's a developing area of law, it's actually really a developing area of legal practice. How the court system, and in this case also the tribunal system, deals with self-represented litigants. It's an interesting area. It's an interesting phenomenon. The idea that for a long time, it was very much frowned upon, particularly in the courts. People representing themselves in the courts. But there's a trend in our legal system to give citizens the power to be heard. If people want to go through the court system themselves, and they want to go through and face off against the state of Queensland or the Commonwealth of Australia, stand up for themselves. A part of us intuitively feels that is actually kind of neat, and it's kind of important, and it's something that we ought to, in some ways, perhaps not encourage, but at least facilitate in some way. But this something maybe this will change over time. Even though the tribunals do have guidelines for their members, guidelines for the support staff, guidelines for the registry staff to assist self-represented litigants to go through the process, it is not an error of law if they don't. You aren't going to be able to seek recourse to the Federal Court or to the Queensland Supreme Court if you as a self-represented litigant aren't told of a variety of things as part of that process. But one of the nice things about tribunals is that they are inquisitorial. So they can guide self-represented litigants through this process by asking questions. They're allowed to go through and ask the litigant direct questions. This is something where you don't get in the court system. You do see it as a matter of practicality, and particularly in the low-level courts, where judges will directly ask things, where's this paperwork, where's this thing, where's the keeping eye, but particularly the further up you go, the more adversarial the process is, and the more the judge steps away, listens to the two sides talk. Okay, and so this idea of member, we use the term member to describe the quasi-judicial function of the person presiding over a matter in QCAT on the AAT. But they're re-examining evidence, and they are to take an active role in doing that. Unlike the courts, it's not a passive role where the two sides rock up and make an argument. Members control physical hearing. You stand up now, you will ask questions of, you will want to ask some more questions of, and so on. So you don't have this idea of one side adduces evidence, then the other ones, then they sit down, then you make a ruling. They don't have any powers of contempt, so they can't literally have you locked up for being disrespectful. But they do have the power to end your matter if you are disrespectful at a particular point, and the power to adjourn. But it's important, though, that because the member is actively part of this process, this inquisitorial process, there can be a bit of a problem with personalities, particularly if you are a particularly abrasive person trying to seek review of decision in the AT or in QCAT, and that can be problematic because you need to develop a relationship as part of this process. It's the nature of the communication process to develop a relationship with a person, even if it is just for them fulfilling their impartial role to try and reach the correct and preferable decision. And so that, don't forget that when you're in QCAT. This is a conversation. You're building a relationship. And I'm not saying this just as a source of competitive advantage. It's actually their job. They are an active part of this process, whereas judicial officers and courts are not. They're not supposed to actively be trying to seek the truth. The jury can do that, properly instructed by the courts, and the jury, remember, can ask questions. Juries can come back and ask questions. Your Honour, we need this explained or we need that explained. That's fine. Juries can do that, and the judge, again, instructs the juries how to go through and do that, and then organises for the parties to explain certain things. But members in QCAT and members in the AAT, they take an active part of that particular process. Okay, so what can the AAT do? Because these are all decisions that have been made by under enactment. So there are particular decision makers that have made decision under enactment. Part of the AAT's role is to step into the shoes, exercise all of the powers of that original decision maker, and make the correct and preferable decision. Okay, and one thing they can do is look at this, make some comments, send it back to the original decision maker. And if we think about it, that's a little similar to how some of the remedies in judicial review work. Hey, here's a decision that's been made, let's quash it. Let's get rid of certiorari or an order under the Act. It goes back to the original decision maker for them to remake it. Okay, so that while the tribunal does step into the role of the decision maker, they do have the power to abrogate themselves of that power. Again, they can make comments on particular matters and send it back. But the key thing that they can do that the courts can't is make a new decision and substitute it. That's the key functional difference between merits review and judicial review, and I know I've probably harped on about that for about an hour already, is that the AAT and QCAT are stepping into the shoes of the decision maker. They have the power to remake that decision and replace it. They're not sending it back, not issuing an order of some sort, compelling the administrative decision maker to do or not do something, just changing the decision, changing it with the correct and preferable one based on how they've gone through and weighed those things up. Okay, and so again, this is this section that says those relevant things. That's section 43 of the AAT Act. And there's an equivalent one in Queensland as well, I haven't put it in there. Okay, and so a couple of things to note here is that, yes, while they can remake the correct and preferable decision, sometimes, a non-trivial amount of time, they will look at the original decision and just give it a big tick. Yes, you've sought review, but the original decision was fine. We've looked at it, re-examined it, and we are just going to affirm that original decision. Right. They can either replace it, they can affirm it, or they can send it back to the decision maker with a variety of recommendations. And one of the things to note here is that the recommendations are not binding on decision makers, a bit like declarations are not binding on decision makers. A declaration is a remedy in the court's equitable jurisdiction. For judicial review, this does not, strictly speaking, bind. However, government decision makers very rarely don't follow them. And the same with things that have come back from the AAT. Why is that? Because it would be futile to remake the same decision, do the exact same thing, say, oh, we don't agree with the AAT. It's just going to go back. It's just going to go back to the AAT, and they're just going to replace the decision. You're just wasting everyone's time. Because the decision with all of the matters to be reconsidered is going to form part of the file. It's going to go back to the original decision maker, and if they don't want to follow it, well, more fool them. You're just wasting everyone's time. This is the very last slide, which is this one. Okay. start with that last one, which I've already alluded to before. It's that distinction between inquisitorial and adversarial. And again, that flows from the fact that tribunals are part of the executive. If we think about that from first principles, it's their job to go and do things. Their job, the power given to them under the statute, is to make other decision makers' decisions the correct and preferable ones. That's their job. They've got powers to go through and do that. And we don't, well, we do limit their powers in terms of what they can and can't do. They can't go and spend money to go off investigating. But we do give them powers to fulfill that particular aim. And part of that is to get involved and be active in the process and be inquisitorial, actually ask questions of the parties. Now, that middle one, the middle point there, that tribunals can set aside decisions that are unlawfully made. They can as part of that process. If they go through and investigate and look at a particular statutory framework and they look at what a particular decision maker has done as part of this process and go, that decision wasn't made correctly under this particular enactment, they can set those things aside. They can actually go remake the decision properly under their enactment. And fundamentally, that's their job. The decision that's been made under an enactment that was incorrect in some ways, again, whether it be to do with weightings, whether it to be to do with the quality of the decisions, if it's been made incorrectly, we're not going to limit the tribunal's power to do this. We do say, though, is that where there are errors or defects of law, they make note of this and, again, remake that particular decision, often by sending it back to the relevant decision maker for reconsidering. But if the tribunal is noting that there are errors of law, you can imagine that these things can be a little problematic, because the tribunals aren't courts. And so if they're noting that there's an error of law as part of this process, and of course they do, when they're making their decisions, they have to talk about the law. Them weighing up pieces of evidence and weighing up all of the evidence to do it, it still has to be done within the boundaries of a statutory framework. Don't think that merits reviews are devoid of law. They're not. They have to go through and do this, and they will recognise often where government departments have made things or made decisions that were actually made contrary to law. They can make note of that. Oh, hey, you've made this. We're looking at how all these things have been weighed up, but some of them, the administrative decision maker has put weight on this function. It didn't have the power to do under this particular section. The tribunal can definitely take that into account, and they ought to as part of their decision and part of their process. That aspect of it, sending decisions back to be reconsidered. They don't have to, they can have the decision set there. Again, if the tribunal has made an error in doing that, that's an error of law in itself. And so the relevant minister, or I'm trying to think, depending on which way it's gone, can also go through the federal court to have that particular part heard. But it's important to note that that's different and distinct from the first line, which is to do with the validity of legislation itself, particularly in terms of regulation. Remember that when we were looking at ultra vires, we're thinking about how and where regulation's been made, how broad it is, and whether it fits under the Act. That's not the job of the tribunal, and they know it. It's not their job to determine whether enactments are validly passed or validly fit within the scope of a particular legislative framework. That's not their job. They can make note of it, and they do, but their job is to rehear decisions based on the framework that's given to them. That's just fundamentally how that operates. If you think about it, we here, a bit different from me, but for you guys here, who are essentially the start of your legal training process, you've got a few more years before you're able to go off and give structured advice on a variety of matters. But armed with the information you have now, it would be appropriate to use this information as part of rehearing a decision. actually going through and looking at the rules and the frameworks for doing these things. But we're not courts. We don't have the powers of the court. We don't have the skill of a court to do that. And so while people in tribunals do have this sort of level of training, it's not their job. It's not their role. Role is to go through and re-examine the decision, make the correct and preferable decision based on the framework that's given to them. It's not to challenge that framework. Can challenge things where pieces of information have been given that fall outside of that framework. But fundamentally, it's not their job to look at the legislative instrument itself in terms of how and where it sits in its own validity. Okay. I actually don't have much else to add to that in terms of merits review, but it's worth noting that the themes of this are important. Knowing and understanding where this sits as the mirror opposite of judicial review. Tribunals that are not courts, that are not looking at the quality of the law itself, they're looking at the decision itself. They've still got to operate within that framework, the statutory framework that's given, or the decision was originally made under. And there's a little bit few rules in terms of standing and procedure and so on, but really that's where it's at. It's that idea that this sits in the system of administrative law broadly, but in terms of the underlying rules applying to it, you notice that this is 1 week and it's only 90 minutes. Judicial review is huge, because that's what you guys need to know as solicitors. Merits review is designed in many ways to kind of exclude us from the process. It's about rehearing of decisions and weighing up and looking at evidence in a low-cost, effective manner. If possible, Parliament would like to remove as much of the legal technical stuff from this system as they can. Can't remove all of it, but they try. So I'm going to leave that with you guys to have a ponder, and we'll end it there, and I'll see you on the tube.